Hi, I'm here today to give you some basic or simple explanation on the Sosma trial. Well, the Sosma trial come about this act known as Security Offences Special Measures Act 2012. Now, this applies to security offences. When you say Sosma trial, means you're talking about trial procedure. There are no charges and so on. It's purely a trial procedure. Now, before the Sosma Act was around about in 2012, before that we had the Essential Security Regulation 1975. It had a similar provision with regard to Sosma. In fact, if it's before 2012, if you're talking about security offences, then the trial procedure would be according to ESCA, Essential Security Regulation 1975. And with the Act of Sosma, then therefore now today the trial procedure would be according to the Security Offences Special Measures Act 2012, now known as Sosma. Now we're talking about security offences and what is security offences. Of course, before Sosma, security offences would be offences under the ISA and offences under the wherever the Attorney General is certified to be a security of the Federation. Today, what is security offences are basically offences under the Chapter 6A, 6B of the Penal Code, and also for the offences under the Anti-Trafficking in Person, Anti-Smuggling of Migrants, and Special Measures Against Terrorism of Foreign Countries Act. So this would be the coverage of the security offence. Now, when someone is going to be tried according to security offence, committed security offence, then the trial procedure will take place in the High Court. So, as a preliminary appearance in the court, you will be in the Magistrate or Sessions Court, whichever designated court. Then once a SOSMA comes into play, then it will be transferred into the High Court, where the High Court will have the trial procedure according to SOSMA. Now, the unhappiness about SOSMA is basically, first of all, the detention and arrest power by the police, which can up to be 28 days, and then the evidence in court can be lax. Child evidence tendered in court, there's a lax of procedure regarding the tendering of child evidence in court, and then the protection of informers in a way that you're not there's specific provision in section 14 which says that the identity of the prosecution may refuse to have the identity of a witness to be disclosed in a manner it would not be heard by both the accused and his counsel, and may make an application before the court. So the identity of the person would be unknown, and then and more so, there's another interesting provision in SOSMA is that even the person has succeeded in this case by getting an acquittal, and if then an appeal is being filed by the prosecution, then by virtue of the SOSMA trial, he'll be still detained pending the matter to be heard in the appellate courts. So this is one salient feature that it is also creates total unhappiness, despite the person getting an acquittal, yet he is still remanded in prison until the appeal is being heard of. Well, this is the general input that is regard to SOSMA trial. But more so, moving forward, either we repeal the entire SOSMA Act, because if one were to look between the SOSMA and before SOSMA ESCA, virtually similar provisions are in SOSMA. And in fact, in SOSMA, the most stringent, provisions, in a way, go against contrary to the rule of law with regard to the nature of evidence, total flexibility of evidence, and so on. And it's open to abuse. That's the most fearful issue here. Why there's so much talk and so much unhappiness in this SOSMA trial procedure. So one is we repeal all, and if you repeal, what do you have? Then if what we have now, then will be the Criminal Procedure Code and the Evidence Act, and it is sufficient enough. It governs enough. In fact, the terrorism offences are legislated under the Penal Code, and of course CPC does come into play. So we have CPC, we have Evidence Act, so that's sufficient enough. With regard to bail, again, that will be discretion of the court. Let the wisdom of the judge decide on this issue, which they are all competent enough to look at this issue of whether bail should be given in cases involving what do you call it, terrorism and so on. So we can do away. I think that's the way forward. And if we intend to keep Sosma, then he has to go a major overhaul, a clear review. Because according to legislation, they're supposed to have a review every 5 years. So I don't know whether review has been done, but the review must not just be a mere mechanical exercise. No? There must be some real thoughts given to the provisions of Sosma, so that there's a balance for all parties, right? So that's about it. I hope you enjoy this short and simple explanation on Sosma. Thank you.